morning. May it please the court. My name is Aaron Daniel, also from Kula and Associates. Here on behalf of Wells Fargo, I'd like to reserve 2 minutes for rebuttal. As this court has said, the law does not always provide a good roadmap for trial courts. In this area of sanctioning non-compliant parties, however, our Supreme Court has done just that. When the trial court fails to follow that roadmap, reversal is warranted. PNC Bank versus Duke, 137 Southern 3rd, 476. And there, this court reversed for failure to follow the Supreme Court's requirements in Kozel versus Ostendorf. Similarly, here, the trial court failed to make any express written factual findings in its order dismissing Wells Fargo's claim as a sanction. I'd like to just read that order. The entirety of the order states, case is dismissed based on the willful and intentional violation of prior court orders. That's it. No mention of an analysis of the 6 factors, arguably mentioning the first factor, intentional or neglectful disobedience by the trial counsel. But without...
Counsel, let me ask this,
yes.
because it strikes me that we see enough of these foreclosure cases, and it does seem from time to time there is a concern by the trial court that orders are entered about preparing for trial and parties aren't following it, and something needs to be done about it. In this case, as I understand it, there was a motion for an involuntary dismissal and a motion in limine. Okay? The upshot of the motion in limine, I assume, was don't allow certain evidence in because prior court orders have not been complied with. So my question is, my understanding is that Judge Colton, on a previous violation, said the bank is going to use this witness. That witness was in the courtroom, and the judge said, that witness is going to be deposed before trial, and that's the only witness that you can use. Okay? Day of trial, my understanding is that witness is not in the courtroom. So my question is that if the trial judge on that occasion didn't grant an involuntary dismissal, but granted the motion in limine and said, you know, I previously ordered, that's going to be your witness, let's proceed. It doesn't seem to me that Kozel would apply in that situation, and if the judge had decided to grant a motion in limine, that effectively would have gutted your case, right?
Correct, Your Honor, but also in our response to the motion in limine, we did argue Binger, and we did argue that a motion in limine would not have been proper at that time for various reasons. But that would have been a lesser sanction, certainly, and the court didn't grant that lesser sanction and didn't consider the factors. And we're not here to defend the actions of trial counsel. We readily concede that the disobedience was sanctionable. And we're not going to defend trial counsel. We're here to defend the rights of our client, Wells Fargo.
Well, they, of course, were part of it because the woman was there and said she was taking down notes to say, okay, or something like that. When are you supposed to be there? And she doesn't show up.
Yeah,
I mean, clearly Wells Fargo knew something was going on and didn't do that. So my question, I guess, about what you think we should do on remand, assuming we say, yeah, you're right, it's black letter law, the judge didn't make the findings, it has to go back. But your position is, but we should tell the judge, oh no, he could never dismiss this case based upon a Kozel analysis.
Well,
and that's what surprises me.
To the extent, Your Honor, that we argued proportionality, that proportionality prong that the sentence didn't fit the crime, we were trying to preserve the interests of our client and show that ultimate dismissal was not appropriate here. And Your Honor is referring to, I think, one line in the transcript where counsel for the borrower didn't testify, represented that someone from Wells Fargo had been there and had her date books. But even that, I would submit, is really evidence of neglect and not keeping dates open. And a date certain wasn't set at that hearing.
Well, it doesn't matter. She knew, somebody from Wells Fargo knew that person was going to have to be there, and they show up, and They say, oh, we're going to use somebody else.
That's-
And oh, by the way, the lawyers didn't even read the orders to know what they were supposed to do.
That's right, Your Honor. And again, we're not defending the actions of trial counsel. And to the extent that our briefs seem to suggest that we're defending, we would submit that it's not, and we would withdraw any portions that look like a defense of clearly sanctionable actions. We just wanted to say that to the extent this court would like to engage in a proportionality analysis in the first instance, because that was never done in the trial court, and certainly there's no express written findings of fact in the first instance, there is support, Ham, for instance, as well as PNC Bank versus Duke, for remand for the findings, but also taking the ultimate sanction off the table. And so that was...
Okay, but I
was
still
our
want to go back to what again, I'm starting to perceive from reading briefs and records is a significant problem in the trial court with these foreclosure cases, because if I'm understanding it correctly, a lot of times the bank is responding, who are your witnesses, and they'll give a string of like 20 or 50 witnesses or whatever, because there's this phenomenon out there now, if I understand it correctly, where the bank just hires someone to come in and testify, and that person will look at a file 2 or 3 days before the trial, and that's the extent of their involvement in terms of preparing. So I can imagine they've got these bank of witnesses, and it just strikes me as unfair when the bank will consistently run up on the day of trial, and the defense is never given a fair opportunity to depose. And in this instance, I think the judge was trying to deal with that problem and said, that's going to be your witness, that's the person that needs to show up at trial, and that's still ignored. I mean...
No, I absolutely agree with you, Your Honor, and we lament the fact that it took so long for this to come to a head. But I will say that prejudice in defending the case is, I think, what you're getting at, is the borrower being able to put on their defense. There is email evidence in the record that shows that the attorneys for Wells Fargo tried to make the witness available 2 weeks prior. Now, you're right, this was outside of the window that had been set by the court twice previously, and we're not defending the inability to set it.
Which witness did they try to make available? The one that they were supposed to, or this new one that showed up at trial?
Yes, Your Honor, the new Maria Perez, who was the witness they were supposed to make available, they attempted to make available 2 weeks prior to trial.
And so, having not been able to make her available, they show up with somebody else?
We're not defending. We're just trying to voice concern.
We're giving you a hard time, and it's not. I understand.
Except
I apologize.
my concern is that it's really not the attorney that's dropping the ball. It's the client who's not cooperating with making the witnesses available. So,
we would submit there's no evidence.
You're coming in, and the lawyers are falling on their sword, saying, "Judge, don't penalize my client because I didn't get something done." And I'm concerned that that's maybe not what's really going on. What's really going on is the banks are not cooperating because, for whatever reason, the volume or whatever explanation they've got for that.
That's correct, Your Honor. And to that, I would just say that Kozel is very stern in saying, and Ham v. Dunmire, that the express findings have to be made in the record in the first instance and not ex post facto on appeal. In a de novo, standard of review is abuse of discretion. Without the express written findings of fact, this court has said we have nothing to guide our analysis of the court's thought process in exercising that discretion. And so I would respectfully submit that without the express written findings of fact, this order must be reversed and remanded to the lower court. I would like to reserve the rest of my time for rebuttal.
Okay, thank you.
Good morning, may it please the court. My name is Michael Votter of the Ticton Law Group. I was trial counsel that attended each of the hearings leading up to the Anish trial. I also attended the trial and argued.
Well, isn't there a problem that the judge just didn't make the Kozel factors? I mean, it's pretty clear from the case law that he has to do that.
Well, what we're looking at is an order of trial, an order setting trial, and the court's inherent authority to regulate its trial orders. Now, Judge Oftedal did conduct a mini evidentiary hearing at the time of this order the order that's being appealed being entered, and he asked the counsel for the bank that was present, he asked myself about each of the issues, and he made the specific finding that there was willful noncompliance with the prior order and intentional noncompliance with the prior orders. And this was a pattern of activity. It's the idea of 3 strikes and you're out. We had this happen in June where they listed 9 witnesses and then the bank showed up with a 10th witness. So Judge Colton said, all right, this isn't fair to show up on the day of trial with a new witness, so I'm going to order the bank to list their new witness within 20 days.
And obviously, this is a case where it appears that the judge, if the judge had made all of the findings, including the proportionality, that maybe that the judge would have come to the same conclusion. But doesn't our case law mandate that the judge make those findings?
Well, the Ham v. Dunmeyer case does say there are no magic words that the court needs to include in its order. And we do...
But they have to make findings. Don't we say they have to make the findings?
I agree that...
Other than, I mean, obviously he did willful and intentional.
Right.
But that's like a conclusion of law that allows you to do it. Doesn't our case law say you have to make the Kozel findings?
You can't really contend, can you, that the brief order that was just read to us satisfies Ham and Kozel?
Not in terms of the language of the order, but the findings that occurred during the hearing in the discussion of what occurred when Judge Oftedal was asking the questions.
So what you're saying is, look to the transcript, and if it's in the transcript that he made those findings, the fact that it's not in the order itself is okay.
Yes, Judge.
And he made all the findings in the transcript.
Yes, our position is that the transcript did include each of the 6 aspects of Kozel.
Well, that might have worked if the judge said for the reasons contained in the transcript of the record or something to that effect, but he didn't do that.
Right, but it was also a motion in limine combined with the motion for involuntary dismissal.
But I read nothing in that order that talked about granting the motion in limine.
The word is just simply granted, the action is dismissed. So that there is a little bit of ambiguity within the court's order at that point. I do know that this was a situation in which there was a continuous pattern by the plaintiff, and the question then becomes by the court is, well, what's going to happen if this case is remanded? Is the court going to find the applicability and be able to enter the express findings? Is it because there was taxing of the trial docket? You know, a day was set aside in June, a day was set aside in August, a day was set aside in October. The courts, there was prejudice to the defendant based upon looking at even the Reeve case. These witnesses, these corporate representatives are not fungible items. These are individuals that have...
You basically, you're surmising. In your brief you say, when Judge Oftedal says their position is they'd like to take the deposition in a timely fashion, not on the eve of trial, and you're saying that's the factor in terms of prejudice. You may be right, but that he doesn't say that. I mean, you're surmising a lot of this here.
Right, based upon prior situations in which even this court in the Reeve case said that when a witness changes on the eve of trial, you know, it creates an undue prejudice to the opposing side to have to do a deposition at the very last moment before trial, because these depositions are utilized in trial proceedings. They're utilized for impeachment and other purposes.
Isn't the real reason why we need the findings here? Because Kozel was really an issue, as is Ham and all the progeny from there on, are talking about, is it fair to dismiss a litigant's case because of the misconduct of its lawyer? I mean, that's the real bottom line, because you never know. And so that's why you have to weigh all these things. And we don't have, I mean, we have evidence that the client was involved and that's what's going to happen, but we don't have the judge saying that.
I agree, Judge. And I was down there in courtroom 4A before Judge Colton. Ms. Perez was right there. Judge Colton spoke directly to Ms. Perez, the witness, and said, Ms. Perez, you're going to be the witness. She had her pocketbook out. She made notes as to when the new trial was going to be. And then the day of trial, she does not show up anywhere at the trial. An entirely different witness shows up. And that was already now the 3rd time in which there had been a witness.
Maybe that was the lawyer's fault. Maybe it was the lawyer that said, look, you don't have to show up. We don't know that at this point. The judge could say, look, the judge could rely on what you're saying, the judge could do all kinds of things and make those findings, and had the judge made those findings, probably even if he had made them on the record saying, look, the banks was all involved in this is all their fault, I would have been fine with that. But we don't, under COSL, we're supposed to have express findings, so we can evaluate whether or not the sanction was too severe.
Right, and the distinguishing factor in the instant case versus a lot of the other recent cases that I've analyzed, COSL, is the fact that here we're not dealing with an amendment of an initial pleading. We're not dealing with a singular discovery violation. I know that in the COSIS case that was recently issued by the court last week, there was the discussion as, there was no findings, the order was completely silent. That was the first discovery violation. Here we have the pattern of activity, and we have the trial court, which states in its trial order, which is part of the record, that failure to comply with the trial orders will result in sanctions, including dismissal. So the party is already.
What if we were to say here, affirm and say, you know what, because we see this in the record, because we see all this, we think that the trial judge was justified in dismissing this for willful and under COSL. What does that say for all the other cases? I mean, part of the reason why we want findings is to make sure they're all done and they're all, and it's not, because we're a reviewing court, we're not supposed to be a finder of fact in the first instance. I just worry that if we don't adhere to this, then trial judges will not be clear, and now we're in the position of trying to judge on a cold record the involvement and what have you.
No, I understand the court's concern. However, when we're looking at this, the court has its own authority to regulate its orders. And if the court does make a finding at trial, remember these situations occurred the day of trial, the court must be looked at as whether it's an abuse of their discretion. And there is not an abuse of the discretion when the court has the inherent authority. It's notified the parties, it's notified the lawyers on each side that it has trial orders, and these trial orders are to be complied with. If the court states that, if the appellate court states that there is no teeth in these orders or no authority within these orders to be enforced, then we're going to have a much greater situation.
Well, we're not saying that. We're just saying enforce them in the way they're supposed to be enforced. I mean, we would reverse if we did to say make the findings.
Right. It all comes down to whether or not there is competent and substantial evidence within the record. And our position is that there is competent and substantial evidence within the record to support my client's position in this particular case. We have 3 prior situations. There were lesser sanctions that were issued against the bank. Those were not complied with. The prior orders, which allowed for a potential opportunity to cure the issues of showing up with a different witness, that was not complied with. Then we have on this 3rd day where a different witness shows up that then was ordered. The bank had not paid the fine that had been imposed on it as a prior sanction.
Well, why didn't you ask the judge to write an order saying with all the COSO findings in it? Saying, Judge, you have to make those findings.
Right. In retrospect, that would have been a great thing to do. This was one of those days where there was 200 folks in the courtroom. It was we were pulled in during a uniform motion calendar, and unfortunately that
I thought you said this
occur.
was the start of trial.
The trial began at 9:30.
Oh, okay, so you were doing this beforehand.
So the trial judge it was actually Judge Brunson we were before, and when there was the motion limiting brought up, she said, I want you to go to Judge Oftedal and have him roll on the motion limiting. So the uniform motion calendar was suspended, basically. The attorneys came in, myself and the plaintiff's attorney, and we made our arguments at that point. So we ask that the court affirm the trial court's decision. Thank you for your time.
I would just like to refer the court back to Ham v. Dunmeyer. The dismissal of an action based on violations of discovery order will constitute an abuse of discretion where the court fails to make express written findings of fact. The court absolutely has discretion, but that discretion is cabined and funneled by the causal analysis so that we can make sure that in going through the analysis, in considering each factor, that these are not the circumstances that rise to the level where the client should be sanctioned. And again, in Ham v. Dunmeyer, the Supreme Court went through a list of cases of extreme egregious conduct that did support the ultimate sanction despite the lack of client participation. And one of those was Schlitt v. Courier from this court in 2000, where there were 13 motions to compel, 3 monetary sanctions orders, several court orders threatening dismissal. That type of extreme conduct, the court intimated, would support dismissal, but those aren't these facts. And our facts are quite bare without those express findings. The transcript is quite bare. And, you know, at the end of the day, prejudice is one of those factors. And here, where the borrower's monthly obligations are suspended pending litigation and acceleration of the loan, delay is at minimum a net wash. But that's, again, weighing the evidence in the first instance, and we would submit that that has to be done by the trial court. So we respectfully request a remand for that.
Thank you very much. Court is adjourned.